Hello everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. This week's second part to this week's material, part 2, deals with loyalty, confidentiality and privacy, and we're talking about the material which appears in Chapter 13 of your textbook, Stewart's Guide. If you want to do any additional reading, have a look at Creighton and Stewart's Labour Law on the chapters that are indicated there, 14.1, 14.2, 17.6 and 17.7. But just to start the conversation, the textbook authors ask you to think about fidelity, the whole idea of a duty to serve an employer faithfully, and of course they draw the conclusion that the duty fits pretty nicely with what we talked about last chapter, obedience, cooperation and proper conduct. So it's in the same sort of category. So a duty to serve your employer faithfully, it continues as long as the employment contract continues, but most often it deals with competition between the employer and the employee. The text refers to the case of Harris and Digital Pulse, and in that case the web designers, the marketing and web design people, were working secretly for the benefit of a business which they had created. They were taking business directly from their employer and making a profit from it, and they were ultimately required to pay over that profit and also pay some exemplary damages. So good case given as an example. Acts done in preparation for a new enterprise is quite a complex area, and I'll pause for a minute in talking about the textbook to say please have a look at the material I put up on the Moodle site regarding a crime and misconduct investigation a few years ago into what happens when a state public sector employee leaves that agency and goes to work for a private provider. In that case, it was various staff that were working at TAFE in Brisbane, went off to private providers. I can't say that the report leads to any great changes within Queensland, but certainly it was quite topical at the time, and I think it's worth a look. So soliciting soliciting an employer's client to switch businesses to come across and work for a new business, recruiting other staff from the employer's business, removing and copying information, or just generally assisting a rival business can all be acts done in preparation for moving across into a new business. Having multiple jobs, being too tired to work, working at exactly the same time as you should be working for your employer, moonlighting with a competitor, particularly if you're a senior or a highly skilled employee, these are the sorts of things which are not going to be allowed. Although note the comments about not being unduly restricted by your employer. And I could think of an example of perhaps somebody who had a hobby on the weekend that also earned a profit for them. Any attempt to interfere with that, I would think, would ordinarily, the starting point would be that you'd be thinking they'd be being unduly interfered with, and probably not really a breach of the duty of loyalty. The textbook refers to the prospect of asking an employee to sign an exclusive service agreement and mentions specifically sports and entertainment. So moving away from sports to entertainment for a moment, you'll often find in the television industry, for example, but also in other entertainment industries, past the entertainment industry, contracts that say when you're working for us, you will work for no one else. And that's often because part of what's being built up is a brand or a recognition around that particular employee. So that could be watered down if the person was allowed to go away and work in other areas or for other employers. It's the sort of thing that appears in a managerial contract as well, so not unusual to find in a managerial contract a requirement that says that when you're working for us, it's an exclusive service. Also, I'd make the point here that that doesn't necessarily preclude a person from being a director of another company or even a family company. Usually it's just something that's addressed in the contract. So it'll say, well, exclusive service unless you get our consent. Usually only during the course of employment and not after. And we'll talk in a little while about whether or not that can amount to a restraint of trade, but not such an unusual condition to find in a contract. Now, the authors also talk about employees having fiduciary duties. If you haven't struck this term before, I'll just explain it briefly because you'll bump up against it again when you talk about trustees during your course. And a trustee might, for example, be somebody who's administering a deceased estate. It's usually the situation, a fiduciary is usually a situation where they're doing something on behalf of someone else, and particularly where they're doing something on behalf of someone else who is suffering from some sort of a disability or is in a weaker position. Good examples that are given are company directors, legal practitioners. Put bluntly, a fiduciary is not meant to make a profit from the position they find themselves in. Have a look at those couple of cases that are mentioned in the text. So far as intellectual property is concerned, certainly this is something that's very big in the university business. Intellectual property is regulated when it's something that's created during the course of employment. So there's usually some discussion around that aspect for a start about course of employment, but just identifying the type of intellectual property. Firstly, we're talking about copyright. Now, there is a statutory presumption which gets a mention in the text that anything that's written during the course of your employment is the property of your employer. So that's in the Copyright Act. That is quite distinct, though, from the moral rights or the right of integrity that also was mentioned in your text. And if I just mention moral rights, that's sometimes called upon by university lecturers who are producing material where they want to see something on the notes that says, look, it's nothing to do with ownership. They're simply saying, I'd like my name on there as the author of this material, and that's said to be asserting your moral rights. But copyright, starting position, if you're writing some material, you are writing it for your employer. Note the comments, though, that are made about the different situation if material is not produced during course of employment so much as produced by an independent contractor. In that case, the copyright in the material may very well vest in the contracting company, and the good examples that are given there are people that are doing report writing on behalf of a business. They may well continue to own the copyright. And I'm thinking about the examples that are given there around software, logos, etc. They're often going to, there may in fact be a dispute in due course over those, particularly the copyright aspect, if the third-party contractor who's produced it wishes to use it in another way later on, building on that intellectual property. So good point to be raised by the textbook authors. Again, inventions and patents, there's really only one case that you need to take notice of there, and that's the case of Gray and the University of Western Australia. That case eventually went on to appeal. It cost the university over $10 million to fight, and it was a serious bit of litigation over the production, the invention of a slow release type of chemical medicine, if you will, that was a treatment for liver cancer, but potentially for other cancers as well. Very complicated set of facts. It's certainly not as simple as appears in the textbook. Gray worked for a number of agencies apart from the university. Gray, for example, worked for the Cancer Council, I think, for a while, but he certainly worked for more than one employer, and that's not really mentioned in the text. He was definitely a professor of surgery, but he also practiced as a surgeon himself. What came out of the other end of it, though, that all you need to worry about is there was a finding that really there's no implied duty to invent, and even when a person is doing research, there's no real implied duty that says when you're working for us you have a duty to to invent things. And so all over the country, universities and other research agencies scrambled to make sure that that was spelled out in the terms of an employee's contract. So quite an interesting case if you ever had the time to read the lot. Now, post-employment duties. The big case in this area is Ansell Rubber, which has been kicking around for some time, and it's back in 1967. It's about the making of rubber gloves and the secret process that was involved in that. And essentially, there's a duty post-employment not to breach confidence, not to use secret information, confidential information that anyone would reasonably understand is to be kept as confidential, not to disclose that without consent. And of course, in that case, what happened was the various employees breached that duty to Ansell by going out and involving themselves in another business, producing rubber gloves in a very similar way to the way that Ansell had secretly perfected. There are some limitations on that duty, and we do see this a bit. You even see it in the terms and conditions which appear in contracts, that it really has to be something that was secret. It's not something that's freely circulating around. Not something that one of the terms that's often used is information that is otherwise in the public domain. So it does have to be something that's secret, not freely circulating, and it doesn't include information, if you like, more like skills that are bound into the person's know-how. So clearly, when someone works for an employer, they build up a body of skills, they build up a body of knowledge. And when you just can't separate that away from other information that they've picked up during the course of their employment, then you're probably moving away from the post-employment duty not to breach confidentiality. Actions before the employee leaves, so walking off with email lists, phone records, contact lists, pricing information, all of that will be a breach of the duty. Not just from your recollection alone, and have a look at the beautifully named Chicken and Fowler case that's mentioned in your text. The point that's being made there is if you walk away with a certain amount of knowledge about how a business is run, you can't really unknow it. But what you can't do is you can't walk away with complete records, including, as is said there, email lists and the like. How do you enforce it? It is a bit hit and miss, but most companies who decide they're going to do something about this usually want to do it really quickly. The best way to approach this initially, though, is to put something into the contract before the contract commences. Now, the reason for that, ? Well, it's because entering into the contract is the condition, is the consideration, I should say, for enforcing that contractual term. If it happens afterwards, so in other words, the employee's already started work and the employer decides they want to put some sort of restraint over that employee, then they really need to come up with some form of consideration. So if it's post-employment, if it's a post-employment restraint on confidential or secret information, there needs to be some consideration. You need to be quite specific about what you're talking about. To confidentiality, or is it a clause that you will not solicit business? So, just to make that point again, if you're trying to enforce it, put it in the contract before the person's engaged. If it's after their engagement, you'll need to give them some additional consideration. There is some talk in the textbook about getting them to sign a deed, but I have my doubts about that, to be frank. I think the better way is to think about paying them additional sums of money, or to confirm that there's a new term being added to their contract that says that post-employment, now that you're working in this confidential area, you will not disclose that information. You could, of course, enter into a fresh contract. So the textbook authors are making the point here about confidentiality being one type of clause or agreement, and then another one, which is much more specific, is an agreement that just says you will not solicit business for X number of months after you leave our employment. In other words, a non-competition clause. Interestingly, the Competition and Consumer Act doesn't apply to this, so the Section 51(2)(b) that's mentioned in the text is quite clear on this. It says, well, restraint of trade laws don't apply to post-employment restrictions, but the common law restraint of trade still applies, and it gets a mention in Section 4M of the Competition and Consumer Act. Whether or not a restraint is reasonable, so those different types of clauses we mentioned before, just jump back to them. Confidentiality versus non-soliciting, non-competition clauses. If any of those clauses is going to stick, they need to be reasonable. And what is reasonable is judged against two different tests. Does the employer have a really legitimate interest, and is the scope appropriate? So legitimate interest really can't be, and I think your textbook authors make this point, can't be, oh look, I'd like to do this so I don't have to compete with somebody else in the marketplace. That's not good enough. I don't want another competitor to take up a person who's been a fairly valuable employee. That's not good enough either. A legitimate interest is going to be something like this: confidential information that's beyond mere know-how. So I said before, everybody's entitled to walk away from their job with increased skills. Presumably that's one of the things that you do when you leave. But it's got to be more than that. It's got to be confidential information beyond that mere know-how. Personal contact with the employer's customers. So that's obviously in the area of sales. People who work as sales reps, they've got personal contact with the employer's customers. They've built up a relationship. There's some danger there. It's a really legitimate interest which needs to be protected. Poaching staff gets a mention as an emerging area, and I think I would tend to agree with that, although the textbook authors are a bit saying it's a bit still out there. That the idea that someone, particularly in a large law firm, could pack up and take most of their division with them is of real concern to some of the big law firms. So I think I agree with number 3. But that works in conjunction with scope. So it's not enough just to say legitimate interest, so confidential information, personal contact, poaching staff. There also has to be balanced against scope. Clauses that are whole of industry based, so cannot work in the plastic industries, was an example given in the text. Just going to be seen to be too broad. Although I'll come back to that in a second. There is a very old example that where that was upheld. So whole of industry is just not going to fly usually. Geographical depends on the sort of business. It would seem to be very difficult not to be allowed to practice, for example, as a solicitor in a small town. There'd have to be some pretty good reasons. So it just will depend on the geographical base that's trying to be enforced. Time can't be too long, although note the textbook's comments on that could be anywhere from 3 to 6 months to even up to 2 years in particular circumstances. Limited to former clients. I think that one works very well. I have seen that work quite well. So a limitation not against going out and finding new business, but against poaching existing clients will generally work. Now that industry-based one, I'm reminded of a case that goes back to the beginning of last century, to be frank, and it was called the Nordenfelt Maxim case, where the marketplace was for weapons, and the particular thing was the Nordenfelt machine gun, and the whole world was said to be a legitimate restraint in the case of something that had such a small market. It was really it was the sort of weapon that armies were going to purchase. So, look, that's a pretty exceptional thing. Industry-based, yeah, I think we'll have problems. Severance and reading down. Note the comment regarding cascading clauses. They are in use. You do see them. that's the clause that reads something along these lines: for a period of 3, restraining a person from competing in the marketplace for a period of 6 months, but if a court finds that to be too broad, then 3 months, but if that's too broad, then 1 month. So you will see that. It does provide a little bit of uncertainty for the person that's signing it, but there do seem to be clauses that if they're not drafted too wildly, courts will uphold. The reason that they are drafted that way, that cascading 3 month, but if that's say 12 months, but if that's too much, 6 months, if that's too much, 3 months, is the court needs to be able to grip on to something to sever. They won't rewrite, a court won't rewrite a contract, but it will look at severing something. Injunctions are probably the preferred remedy. All right, look, on the tail end of that chapter 13, note, in relation to whistleblowers, note those 2 pieces of legislation. If you're in Queensland, do have a look at the Public Interest Disclosure Act, and what you're seeing there is an exception to the rule, the common law rule about disclosing confidential information about your employer in a situation where there is some wrongdoing happening. Have a look at public interest disclosures, see how they work, because sometimes people can think they are making a public interest disclosure and they are not. Note also the comments regarding the Corporations Act, particularly the requirement to note to notify ASIC. You can't really be out telling the world at large. You can make a disclosure, but if it's about misbehaviour in a corporation, that has to be made to the Australian Securities and Investments Commission. And then finally, just in relation to confidentiality and privacy, just be aware of the existence of the Commonwealth Privacy Act. It does apply mainly to Commonwealth agencies, so it's a government thing, but also it applies to confidentiality around health information and for very large businesses that have a turnover of more than $3 million a year. What it does, it creates a set of information privacy principles, or IPPs, that relate to the collection, the storing and the sharing of information. So if you get a chance, if you do nothing else in relation to confidentiality and privacy, see if you can track down those IPPs. There's only a number of them. Just have a look at them and see how they work. As I say, they relate to collection, storing and sharing. Okay, well look, next part we're going to have a talk about discrimination and victimisation, and I'll tell you in advance I'm particularly interested in talking about protected action, which I think is something that is emerging as an issue. So that will be the next presentation. Talk soon.